An executive magistrate is empowered to issue orders for the removal of hazardous trees under sections 133 to 143 of the Criminal Procedure Code, corresponding to sections 152 to 162 of the Bharatiya Nagarik Suraksha Sanhita. These sections address issues of public nuisance. Although public nuisance as defined in section 268 of the Indian Penal Code, corresponding to section 270 of the Bharatiya Nyaya Sanhita, involves a common injury or danger to the public, this definition does not strictly apply to section 133 of the CrPC, corresponding to section 152 of the Bharatiya Nagarik Suraksha Sanhita. In the case of Balakrishnan Nambiar versus Madhavan Nambiar, it was clarified that a magistrate can act under section 133 corresponding to section 152 of the Bharatiya Nagarik Suraksha Sanhita without the necessity of proving danger to the general public. For the purpose of section 133(1)d, corresponding to section 152(1)d of the Bharatiya Nagarik Suraksha Sanhita, it is enough if the building, tree or structure is in such a condition that it is likely to fall and thereby cause injury to persons living or carrying on business in the neighborhood or passing by. It is not necessary that the dangerous position of the tree is such that it is likely to fall in a public place. Likely danger to the public or the entire residents of the neighborhood is also not absolutely essential. Even possible danger to a single individual may become sufficient in specified cases. Also, the branches that overhang into a neighbor's property can be considered a nuisance, regardless of whether they pose a danger to life. This type of nuisance can be addressed through a civil suit for the removal of the offending branches. The right to address this issue is supported by the Easement Act and relevant case law. According to Section 17B of the Easement Act, the right to the free passage of light or air to an open space cannot be acquired by prescription. Section 7, together with Illustration D, upholds the natural right of every owner of land to so much light and air as pass vertically thereto. A conjoint reading of both provisions shows that every landowner has the right to light and air passing vertically to the land and cannot acquire any right to light and air passing horizontally. The overhanging branches, no doubt, cause hindrance to the free passage of light and air vertically to the land. There is a view that the affected landowner can cut and remove the protruding branches themselves. However, it appears better to approach the civil court for the removal of the overhanging branches. This right was upheld in judgment of Mathew versus Uthuppu Thomman. In the said judgment, the court ruled that in a case where there is evidence of branches overhanging from the defendant's property to the plaintiff's property, the latter can always seek a mandatory injunction. This cannot be denied on the ground that there is no evidence of any damage to the plaintiff. Proof of actual damage is not necessary. Whenever the court finds that overhanging branches cause nuisance to the plaintiff or prevent the plaintiff from enjoying their property optimally, the plaintiff can always seek a mandatory injunction for the cutting and removal of the protruding branches. In summary, an executive magistrate can order the removal of dangerous trees if they pose a threat to any individual. Overhanging branches, however, are typically addressed through civil legal actions to abate the nuisance. Therefore, in cases involving overhanging branches of a tree, the remedy is to file a civil suit. If you found this video helpful, please like and share it with others. Subscribe to our channel for more legal insights.